Yes.
Before the short adjournment, the law was asking about the point in the relationship for which notice is given, and I suggested there was authority. That's the alpha lettings case, which we haven't looked at before. It's authority in tab 21. There's an unreported decision of the Court of Appeal about the determination of the exclusive agency. Bundle 2, tab 21. And at paragraph 30, the judgment of Lord Justice Longman, there is a discussion about the appropriate notice for termination of such agreements. Lord Justice Longman begins by saying with little authoritative guidance on the appropriate notice for termination of exclusive agencies, or as lawyers sometimes first call them distributorships, that outlines a couple of possible views. 31 discusses the question of formality, and at 32 is the point my lord had in mind, which is the employee analogy.
Thank you.
That's far as the authorities appear to take that point, Lord. That might be regarded as more in the nature of judicial musing than anything firmer than that.
Yeah.
There's another point raised in the question of lighthouse listings. We've been back through the judgment, but we can't find the reference to the lighthouse point in the judgment.
Okay.
Unless there's anything else I can be of assistance in relation to.
No, thank you very much indeed. Yes.
The cause is well familiar with the principles to be adopted on appeals of the fact. We've chosen to rely on Phage and what Lord Justice Lewis said there.
I think, Mr. Reid, you're just going to have to keep your voice up slightly higher.
So sorry.
No, it's quite all right.
So in Phage, Lord Justice Lewison gave a summary of how appellate courts should deal with issues of appeals on fact, and unless I need to go there, I don't propose to. But one of the main points is that the trial is not a dress rehearsal, as is put, it's the first and last night of the show. And this is a case, I say, or this is an appeal, whereby the trial has been treated as a dress rehearsal. And we are in a situation where either the criticisms that are levelled at the judge are wrong, or it's simply another bite at the cherry, having got a factual matrix now to try and plug in some more legal elements to come to a different conclusion. And we can make that point good by looking at the pleaded case. If we could start, please, in the core bundle, tab 12, page 167. Now, the Hammonds have had some difficulty in putting together the framework in which they say this overarching agreement comes into being. And we can see that because we have a re-amended defence and counterclaim. And if we work that through, we start at paragraph 17 of that document, where we all know what is said there about this being the core of the agreement of what was orally agreed. But then we have these crucial terms, the sentence at the end, 2 sentences. The avoidance of doubt, Mr. Hammond is unable to recall the precise words used by himself or those used by Mr. Sharp. The particulars pleaded represent the gist of the words used. So this is really a summary of what was said, and one can easily imagine a meeting taking place from a manufacturer of gins saying, well, we've got this product, will you be our wholesaler? And the answer is, yes, we'll be your wholesaler. that then develops over time into, we look at paragraph 18, also on page 167. So it said that it was a term to be implied into the agreement, referred to at 17 above, and this is where the phrase the master wholesale agreement is coined. Then we get this amendment, but we don't need to worry about that. Whether by reason of necessity to achieve the obvious intentions of the party and or for business efficacy, or otherwise, that the master wholesale agreement will be terminated by either HOC or ZL only upon the provision of a reasonable notice period. And then there are some particulars given there as to why that notice period comes into being. There are no other terms pleaded. My learned friend now seemingly seeks to fill holes and plug gaps in this agreement that he says exists by saying, well, of course the court could easily imply terms, but that was never the case. One might expect there to be a pleading of, well, there would be an implied term as to price, or there would be a determination of volume in this way, or it's certainly this is going to be dealt with in a reasonable way, or this is the mechanism by which it's going to be dealt with. So that's not how the case was pleaded.
Well, as I understand the case now being put before the court, he is relying on your admissions.
Well, but the admissions are only in relation to those very specific, that they would promote generally to the marketplace, that act as wholesaler and supply products. But we can't go any further and say, well, the express agreement had any other terms within it other than that bare minimum, which we say quite clearly has so little content, as the judge said, that you can't get anything from it.
Well, if I may say so, that's why I was seeking to identify from Mr. Edwards what in fact the court was now being told were the specific terms. And as I understand what he said to the court, they're set out at page 192 in paragraphs 3.2, 3.21, 3.22 and 3.23.
Yes.
Yes.
That is what is contended as being the agreement. My point is that that is clearly unworkable as any kind of enforceable agreement in the way that the HOC wants it to be found. And
sorry, can you just elaborate on? You say that's clearly not workable. Just elaborate exactly why you say.
So we have there's no term in relation to price. I appreciate that it might be a reasonable price, but there's no term in relation to price. There's nothing in relation to volumes. There's nothing in relation to a minimum commitment. There's nothing in relation to duration. There's nothing specific about what promotion is going to be. It is in such general terms that if we played it out to, okay, on the 15th of November 2015 there was this agreement, and then the next day or 2 days later Zymurgorium says, well, actually we've changed our minds, we're walking away. How does that play out? Because it would simply be, well, you said that we would be your wholesaler, you said that you would sell us some products, but there was no obligation to actually do anything. There was no obligation to take any products. It was only when the purchase orders were sent and the corresponding invoices that the relationship started and continued on in that way. There was never a change from that, apart from the one identified, which is the H&A supply, which in itself is, I would argue, a separate agreement in any event, which was, look, you can't make any more, you can only make so much product, so can you outsource this to make as much as you can, because we want to buy more. So that happens, and that's the only scenario where then there's the reverse purchase order. But that's because it wasn't known, for example, how much product was going to come out of H&A. So it wasn't possible to continue the same model of here's a purchase order for 10,000 bottles, when actually the outsourcing may only give 5,000 bottles. So it had to work in that slightly different way. But that is entirely in keeping with the notion of it being separate agreements every time there's a purchase order, other than, well, this exception, which my learned friend seeks to rely on as being a way of saying there's an overarching agreement.
Anyway, I'm sorry, I took you off the line you were going down, so you better go back to it.
The matter, the case then developed, as I said. So we started with paragraph 17, that there was this oral agreement, and that was the agreement in the way that I described. Then we moved to 19B at page 171. And the pleading here is, by reason of the facts and matters pleaded above, the master wholesale agreement, so as defined as being paragraph 17, was varied by conduct so as to add the following terms into the master wholesale agreement. And so, quite clearly, the pleading is, or the case being advanced, is that there was this express agreement, and it was that express agreement that was varied. And it said that the consequence of that is that there are some now further implied terms, 19b1, that Zymurgorium would not directly supply or attempt to directly supply to its products to customers who were the subject of a specific supply agreement, or the master wholesale agreement and or specific supply agreement remaining in force. So, very specific term dealing only with, it's been described as the SSAs. It doesn't import any other exclusivity other than in relation to the SSAs. This is 19b2, that each party will provide the other with reasonable cooperation necessary for the performance of that other party's obligations under or by virtue of the master wholesale agreement or any specific supply agreement. Well, I'm not really sure what that means, other than, well, of course, there needs to be some level of cooperation to understand what volumes might be, if there's going to be an increase in prices because the cost of ingredients go up. But other than that, it doesn't seem to go much further. And then 19b3, that neither party would terminate the master wholesale agreement or any specific supply agreement concluded pursuant to the master wholesale agreement arbitrarily, irrationally, or capriciously. If we stop there for a moment, that's a difficult one, because if it's capriciously, then presumably that's saying, well, you can't, if you just decide one day that you want to end this contract, you can't. But then we have the or at 3.2, without the other's agreement, or alternatively without giving reasonable notice, which in all the circumstances of this matter, Falk alleges would have been at least 12 months. So seemingly it's a way of saying, well, actually the contract was varied to bring in some further termination provisions leading to the 12 months. I'll say this now, but we'll come back to it, is what is missing there is any pleading dealing with an implied contract. The case was never put on the basis of a contract to be implied by the conduct of the parties. That is something, and I can show you where it comes in, it's something that appears to have come for the first time in my learning friend's closing submissions. If we continue on in the pleading, 19.c at page 172, this is where we have, so again, the amendment. Further, alternatively, as a result of the conduct described in paragraph A above, from latest March 2017, the master wholesale agreement referred to as 17 above developed into, if it was not already a relational contract. And it's just worth noting at 19c.6 at the bottom there is the express pleading that whilst there was no express agreement of exclusivity. I started, and I'll just highlight there if I may, that once again, this is a variation on the master wholesale agreement as defined. Just to complete the point I made at the outset, which was that this case is something that's developed over time. When we get to the SSAs, there were similar difficulties. So if we look, please, at page 174, paragraph 21, the way in which it was initially pleaded was in or about April 2018, Hawk, ZL, and JDW entered into a specific supply agreement as follows. So it was actually pleaded initially as a tripartite agreement, which was subsequently rowed back from and amended to being actually there were back-to-back agreements. If we then fast forward, then just to complete the pleading of the cause of action, at 186, under the heading Breach and Renunciation. 22E talks about the transfer of the 27,000. And then at 23, there is the allegation of repudiatory breach or renunciation. Specifically says this: the JDW supply agreement and all other specific supply agreements, or alternatively, in repudiatory breach and or renunciation of the JDW supply agreement, and in particular in breach of the implied terms referred to at 21.4 and 21.8 above, from in or about November or December 2018, ZL began to sell Sweet Violet and Unicorn directly to MC from the supply to JDW, or directly to JDW, and orders received that the orders received from MC, the bottles of Sweet Violet and Unicorn correspondingly declined and then ceased altogether. Now, if we refer back to the implied terms of 21.4 and 21.8, that's at page 176. This appears to be simply the allegations in 1.4.3 that the arrangement would continue on and wouldn't be terminated without reasonable notice. And at 21.8 is that there would be reasonable notice given. So how that was pleaded out, it's not clear how, for example, a relational contract that's said to have been in existence by that point has been breached. It is, I appreciate, a general pleading of repudiation and renunciation, but in terms of what is being said, it is just a general, well, you breached the JDW specific supply agreement and therefore everything comes tumbling down. But it doesn't deal with the issue of, well, why is that not something that's been done in good faith? Is it simply that it would be commercially unacceptable to bring one contract to an end or to supply to a specific specific customer under a specific supply agreement? That is the way in which the scene was set for the trial judge. My learned friend for trial put together a long skeleton argument of 67 pages and 206 paragraphs and subsequent closing submissions of 68 pages and 225 paragraphs. So it was a thorough exercise by my learned friend that the judge was given both pre and post trial. If we start with the skeleton argument, deals with the matter in terms of whether there was a contract or not. So I just copy the page. I'm so sorry. The point is simply this: that the case was open on the basis that it was an express. It was based on the conversation that took place in November of 2015, and the conclusion that is reached at the end of the skeleton argument can be seen at page 120. We're in the supplementary packet now. 201. First, the content of the contractual arrangements between Hock and ZL is a question of fact. It is a question best answered by a close examination of what the parties said and did after mid-November 2018. Then he goes on, second, applying that approach, it's clear that ZL was not entitled to cut out Hock by supplying directly to a Hock customer. ZL's actions from October 2018 approaching and supplying to him CWJW amounted to a breach of that obligation and sufficiently fundamental breach to be repudiatory. So that is how the judge, that's how the case was put to the judge pre-trial. But by the time we get to closing, paragraph 207, page 195. So by this stage, of course, all of the evidence has been heard. And then issue 1, was there an overarching contract between the parties? If so, what were its terms? Is actually now morphed, not into let's look at what the parties said, what was expressly agreed. It is put in 3 ways, as it said. First, there was an express obligation of exclusivity from the start. This is an expression entirely of fact as addressed above. So we know that that was found not to be the case, and that's not challenged. Second, if there was not an obligation of exclusivity at the start, there was a variation implied from conduct to that effect. Now that is quite clearly the variation of the Master Wholesale Agreement. And then third, the agreement between Hock and ZL became, if it was not from the beginning, a relational contract. But that's developed then from paragraph 208 as to say a contract may be implied from conduct. Some law then set out. Then at 211, page 196. In the present case, the analysis is straightforward. If it is not agreed at the outset that Hock would have exclusivity, then the parties' consistent conduct thereafter leads to an implied variation of what was agreed at the outset. I wanted to set that scene because we appear to now be in a position whereby, in terms of ground 1, it's being said that that's being challenged on the basis of the facts don't support the conclusion that the judge came to. But it must follow that if there is no Master Wholesale Agreement or overarching agreement, that grounds 2 and 3 fall away. And my only friend suggested in his submissions this morning that was the case when he said that ground 1 is effectively a stepping stone for grounds.
Okay, but as I heard, he was putting his case on the alternative in ground 2, either a variation or an implied contract.
Well, that may be how he wants to put his case now.
You say that's not how it was put.
And so that's why I say the phrase of the trial is being treated as the dress rehearsal, because having now got a factual finding, it's now being said, oh, well, actually, our case on this is if there wasn't an express agreement that's capable of being enforceable, then look at all of the conduct. And now, that would be a mistake, because that's not how the trial was run. It's not how the parties were set up to argue. That's not how the evidence was put together. The case was put squarely on the basis of there was this meeting in November 2015. This is what was agreed, and everyone continued on after that.
There was a list of issues, agreed list of issues, was there?
Yes.
Where do we find that?
The judge actually sets it out in his judgment at page 92 of the core bundle, paragraph 18. I've taken my lord there because that's how it was a slight tweaking of how it was set up at the CCMC.
Okay, so you're saying the reference to was there an MWA related only to whatever happened in 2015?
Yes, because that was the pleaded case. I found the reference I was looking for in the opening sales argument. It's a supplemental bundle at page 96, paragraph 121. Perhaps worthwhile just going back there, given my lady's question, because this is how it was opened. And it was opened on the basis of oral contracts being the subheading. The rules governing the interpretation of written and oral contracts are very different, and then some principles set out there. And then we're into implied terms, the implied negative. But I had never understood the case advanced at trial to be one of contract by contract. Hence, I say it then comes in later when we get the closing submissions for the first time, having heard the evidence. One might say cynically, realising that that's not going to work, and then trying to find another way of casting that argument. So the consequence of all of that is that the criticisms that are being levelled at the judgment are unfounded, in my submission. The judge was dealing with a sea of evidence, as was set out this morning, in terms of lots of documentary evidence, 8 days of oral evidence and submissions, and has put together a very thorough judgment setting out his findings, and ultimately concluding that there was no overarching agreement. We see that at core bundle page 139, paragraph 134 of the judgment, where the judge explains that there's no exclusivity, which, as I've illustrated, was expressly said to not exist, or to have been agreed at the meeting. Then the contract has little content. But then at 135, the judge summarises all of that and says, accordingly, I'm satisfied that the defendant has failed to prove the existence of a contract on the terms asserted by it, or any terms in November 2015, and that resolves issue 2.1, which I think goes back to...
Sorry, where are you reading from there?
Paragraph 135, page 139. And I would suggest that the judge, therefore, also understood that issue 2.1 was about whether there was an oral express contract rather than something else. Otherwise, you'd have gone on, of course, to say, but I must also consider whether there's an agreement implied by conduct. So, it would not be for this court, I would suggest, to interfere with the judge's findings, having heard all of the evidence about what happened in 2015, made judgments about the witnesses' credibility as to their recollections and so on, having looked at a number of documents dealing with what happened thereafter. It wouldn't be right for the judge to have identified all of the documents that went one way or the other. It is open to him to come to the conclusion that he came to, and there is no reason to interfere with that. We looked at Baird earlier.
Before we look at Baird, as I understand it, the thrust of a case against you is that there is admissions in the defence to counterclaim that we've looked at a number of times, page 192, I think, those admissions admit that certain things were, quotes, agreed. And then it is said, where you have two commercial parties, it's not a domestic or family arrangement, you have two commercial parties who agree things, then A, one assumes that they mean that to be contractually binding, and B, one doesn't strive too hard to find uncertainties, especially when they've gone on to act on that agreement. That's what's said against you. That's not really posited on the basis of factual findings of a judge. It's just this is what you have admitted in your pleadings, has been agreed. What are the legal consequences of that?
It was a point that was made at the trial. The judge deals with, so page 91 of the core bond, the judge sets out in paragraph 15 that the relevant parts of the pleading 3.2, 4.1, and then 16 is therefore tolerably clear from the RRADC, and insofar as it was not clear, and then we've got footnote 6, hot red paragraph 3.2 as at least potentially admitting an agreement contractual effect that might be consistent with the MWA pleaded by Hawk. That clarified at trial that it denies the existence of any of the overarching agreement of contractual effect, whether the MWA or otherwise, but rather concluded there were individual contracts for sale of quantities of those products from time to time. Equally, the alleged individual SSAs are denied. In any event, the alleged express or implied terms are denied. So it was something that was raised at trial, and simply because there was an admission that there had been an agreement, it was quite clear that the case was that there was no overarching agreement other than, will you be my wholesaler, or will you wholesale my products? Yes. Will you supply your drinks so that I can wholesale them? Yes. But does that lead to a conclusion that there is anything that can be enforced? I go back to what happens the day after. If nobody does anything, how is that to be enforced? One would say, oh, okay, would it be appropriate for one party to say, well, you've got to take a reasonable amount of my product? So what is a reasonable amount of product in this scenario? Okay, well, we're going to sell it at this price. Okay, well, what's a reasonable price in that scenario? There's simply so much missing from the discussion that was had in November 2015 for there to be a contract that is in any way enforceable. So it was never intended that walking away from the meeting in November 2015 for either party to actually do anything. Hence, it's not until the first purchase order arrives that anything actually does happen.
So you say that if, having agreed to act as your wholesaler and having agreed to promote your products, Hammonds had actually just not bothered, you would have no complaint.
Well, it would be difficult to see what the complaint would be, because if they said, okay, well, I believe it was said earlier today, what if this had failed miserably? That this was just a product that looked great, that Hammonds thought, let's have a punt on this, see where it goes, and nobody was interested. Then they would have no doubt just taken whatever the stock was at the first purchase order or first couple of purchase orders, and that would have been the end of it. But in the absence of there being any minimum requirements, I just don't see what any party was obliged to do following the meeting on the 15th of November.
Well, what's said against you is that there is a positive obligation at least to promote.
Well, the point, I think as my lady pointed out earlier, it was said that that's just what wholesalers do. So the case was that this wasn't something special that was discussed. It was that you are going to promote, i.e. it's going to be on a list, it's going to be stocked by you. It wasn't, again, I think my learned friend said, it wasn't, this is, okay, we're going to do a really glossy brochure, we're going to send this out to all these people. That's not, again, not what the obligations were. That's not what was discussed. It was simply that as a wholesaler, one's going to want to sell as much product as possible. That invariably involves promotion of products, not just the Zymurgorium products, but any product that the wholesalers, customers, consumers might want. And so that's why it is so general. I say that you can't get to an agreement that is enforceable.
What does your admission at 3.2.3 mean? It's admitted that the claimant agreed to supply its drinks products to the defendant. When you read it with the denial in 3.2.4, what is it that you're accepting was agreed?
Well, so it is simply that we will provide you with stock. It is simple as, it might seem, now we're looking at it looking at it very closely. But in terms of what happened at that meeting, it's an admission that what was agreed, as I sort of said, perhaps in colloquial terms, you will act as wholesaler. As part of that, that involves promotion of drinks. In order to enable you to be our wholesaler, we will supply you with our product. And the way it was put in the counterclaim was that it would be a supply for all of the demand that Hammonds could generate, which was subsequently watered down to best endeavours. So I suggest the watering down itself makes my position even stronger, because there isn't actually an obligation to supply anything. It's simply, well, we will endeavour to supply our products to you.
Well, you can have a contractual obligation that we will try to do something.
Of course.
At any level, whether it's best, reasonable endeavours or some other qualification on it. But you're saying that has no, as put here, has no content, meaning, effect?
What I'm saying is that, and as the judge found, that any manufacturer is going to use best endeavours to try and sell as much product as possible, because that's the nature of being
Well, we need to be careful about the label, probably not best endeavours.
Sorry,
Probably not best endeavours.
no. But I say that makes my position better, because it isn't even, we will supply you with certain products, or, I mean, there was a whole range eventually of products that Zymurgorium created and were sold, and we've seen there's Sweet Violet, Cherry Bakewell and Unicorn and various things, plus there are the premium gins as well, which are the straightforward gins rather than the liqueurs. Let's take this, what was actually going to be supplied under this agreement? Was it any product that Zymurgorium came up with during the...
What you've admitted, what's been admitted here, is the claimant agreed to supply its drinks products. It wouldn't get better, would it, if it was limited to certain products? It just says it's drinks products, that's admitted.
Yes, which I'm saying is, if you've got a wholesaler who's agreeing to wholesale the products, then of course the corollary of that is we will supply you with our products. But I go back to the purchase orders are the key part here, because that's where we get volumes, that's where we get prices, and that's how this relationship went on for a number of years. And that fits entirely with, and works entirely without there being an overarching agreement. It doesn't, whether this was agreed or not, I would say it makes very little difference, because surely they would have just said, oh, we would like some of your product, here's a purchase order.
It wasn't until the purchase orders came along that specificity was identified.
Yeah. And that is the way in which these two companies traded for a very long time. It was only when things fell apart at the end that there was the first idea that there was some overarching agreement. That's why I started with the pleading, because that's something that's developed over time as Hammonds has tried to identify what it says is the overarching agreement. And the judge, I suppose one could look at this as being the admission, if it's being held as being an admission, or this was agreed, it is only one part of it, because we have to then look at, well, okay, it's admitted that that was agreed, but is that agreement in the legal sense, i.e. there is therefore a legally binding agreement after that? And I say that doesn't sit with paragraph 4.1, which is the denial of there being an overarching agreement. So it may be that, with the benefit of hindsight, could have been more specifically pleaded. Everybody knew going into this trial that it was denied there was an overarching agreement.
And just so I'm clear about it, is that because you say there was no intention to create legal relations, or because it was too uncertain, or because, as the judge said, there's no content, there's no obligations at all? What is the basis on which you say that what is admitted to be a series of agreed things are not contractual promises, enforceable contractual promises?
The position on that appears to be two sides of the same coin from the authorities, which is that, so the starting point is whether it was the uncertainty, but there's just a lack of content here. That's my primary point. And the flip side of that, as I said on the authorities, is that evidence is that there's a lack of intention to create legal relations.
When you say lack of content, do you mean lack of certainty, or does the lack of anything that can bite as a contractual term? Because it's not, what's admitted here is not uncertain, inherently uncertain, it's set out.
No, I accept that. That's why I've said it. If you look at it at a very high level, will you be my wholesaler? Yes. Will you sell my products? Yes. That is effectively the contract that would be that stems from 3.2.1 onwards. It's simply that. But what does that mean? How would one come to court and say, well, he didn't wholesale my products. I wasn't supplied with these products. Well, I don't see how the court could deal with that in any sensible way, other than everything would have to be implied as being, well, it's reasonable this or reasonable that. And we can look at an authority about that, but where the court is effectively writing this contract, which is not the way for it to be dealt with.
But in terms of legal characterisation of it, I think you might be saying it can't have been intended to create legal relations, a legal relationship in relation to concepts as vague as this, or concepts as that aren't very tied down. Because there doesn't seem to be any. There doesn't seem to be any inherent uncertainty in the words in the what has been pleaded to.
I think what you're really saying is there wasn't any commitment to do anything specific at all.
Yes,
I think that's what you're really saying.
Yes.
And the argument on the other side which you're facing is this is a commercial relationship. There is a minimum content. There's an agreement by them to promote, put it on their list, and there's an agreement by you to supply. It may not be specific quantities, it may not be an absolute obligation, but that's sufficient to give rise to mutual promises. That's the argument you're facing. It doesn't need to be very detailed or very specific. It's still a commitment.
Well, I was going to say, my lord and ladies, to Baird, which is
Yes.
volume 1, tab 17. Now, if we start, my learned friend set out some of the background or the background in relation to this. And my lord looks at what was said at page 289, paragraph 6. And that this was where there was a pleading of all of the things that were said to form part of the agreement about capacity and acting in a certain way and not acting contrary to interests and so on. And then we look at page 291, paragraph 13. I appreciate this is applying the principles the judge adopted, but 2. All contracts to be enforceable must be sufficiently certain to enable the courts to give effect to the parties' intentions, rather than to give effect to a contract which the court has to write for them. On the other hand, it can be said courts do not incline to adopt nitpicking attitude to such matters and endeavour, where possible, to construe the legislation in a way which gives effect to the parties' bargain. There's a line to be drawn between the generous attitude to making contracts work and striking them down on grounds of uncertainty. Then if we look down paragraph 14, by the letter C. In any event, the alleged terms are far too imprecise to be capable of being enforced. Mr. Field could not say that so long as the implied contract continued with Baird, M&S were prevented from appointing principal suppliers. I cannot understand how the various factors listed by him would work in practice. If M&S's future requirements were for fewer or more expensive garments of a type which Baird was unwilling or unwilling to produce at an acceptable cost, what then? There is, in my judgment, no firm base on which one could ascertain either a particular quantity or a particular share which could be attributed to Baird in the future. Were the alleged contract to have legal effect, then the court would, to all intents and purposes, be making a bargain for the parties rather than seeking to enforce a bargain which they themselves have made. Well, I say, we'll continue on the moment for May, but say that this is exactly this case.
But at this stage, ground 1, the appellant is not seeking, as I understand it, to get the court to write a contract, but rather to reflect something that's in the pleadings. And the judge's decision appears to be on the basis that that does not amount to sufficient content.
If the court isn't going to write it, then where does it go? Because that's why I said I went to the plea case of there's no implied terms pleaded other than reasonable notice. So if the court isn't going to go as far as to say there's a minimum quantity, or you have to supply this particular product, or all the products that are available have to be made available to Hammonds, then other than one could simply say, well, we've got another wholesaler now, so our best endeavours to supply you, I'm afraid, we'll give you some product, but that's it. I don't see where, if the court were to say the trial judge was wrong and that there was an overarching agreement, then we're simply left with you agreed that you would supply. Okay, so we'll just say we're not going to be able to give you any product because using our best endeavours we can't. It seems to me that there must be some minimum level that one has to say you will supply me with X, Y, or Z. And this is the judge's point about exclusivity. Because in the absence of exclusivity, one might think with exclusivity, there's going to be, well, you have to give us everything. You can't go to another wholesaler. It's all through us. But in the absence of a finding of exclusivity being agreed, then there really isn't any content. That's why it was put, I believe, on the basis that there was exclusivity. We are your exclusive wholesaler because you can't go to anyone else. That makes sense, I would suggest, as a as a contract, but it doesn't in its current form, because where does it go, let's say, in terms of breach here? It's going to be said, and let's put to one side any variations that might be argued or that have been argued. It is simply that, I appreciate we're going back and I apologise, but under 3.2, Hammonds will be wholesaler. We will supply products and we'll do our best endeavours to...
Well, they're not pleading best endeavours.
that is their pleading. It is in...
well, sorry, that's not
part
in
18.
the page.
No,
Page 192. I should have clarified.
It's not part of the admission.
no. Well, it was conceded on the basis. Let me make that clear. The pleaded case on the counterclaim, it's page 167, 17.3, was that the ZL would supply its drinks products to Hock to meet the demand for those drinks products that Hock generated and received. So it was put at a high level of, if we receive, so whenever somebody wants this product,
Yeah,
you will meet that.
but I think we
It
understand
was
that
watered
that's
down.
not what was admitted to.
It was that, but it was watered down in the Part 18 response, which is at page, supplemental bundle page 5. The question asked is, it's actually got a reference to paragraph 3.1.1, it's the same section 3. Under that paragraph is the defendant's case that the claimant was obliged to satisfy any and all demand by the defendant and or its customers for its products.
Sorry.
And the answer, by the number 7, the claimant's contractual obligation was to use all reasonable endeavours to meet such demand for its products as Hock generated. It was not an absolute obligation to fulfil any particular order placed by Hock, irrespective of, for example, size and or timing.
What do you say its obligation was? Nothing at all.
Well, I say it was conceded at trial that we would endeavour, or there would be.
I think the word the judge uses is expectation.
Yes, the point being is that any manufacturer is going to want to try and satisfy demand. So it would be a nonsense for anybody to say that that wasn't going to be sought. The point being is it said it wasn't agreed at the meeting, so that is right. There was no express agreement, but it was conceded that, of course, any commercial party selling things is going to want to try and satisfy as much demand as possible.
But your position is that, like any other manufacturer, of course, we would try and meet demand. But there was no overarching commitment to anything that was contractually enforceable. That's your position.
Yes.
So when you admit in 3.2, I'm sorry to keep going back to the admissions, but that is the foundation of ground one. When you admit in 3.2.3, it was agreed that you would supply. You don't mean there to admit that you contractually promised to do anything.
Yes, that's exactly right.
So what is your admission? Just that we will, if you order, we'll try and supply? I mean, what is it? It's just...
Well, that is right, and that's. I suggest that when we looked at the Part 18 response, item D7, the claimant's contractual obligation was to use all reasonable endeavours to meet such demand. It was not an absolute obligation to fulfil any particular order placed by Hock, irrespective of, for example, size and or timing. So even the defendant, even Hammonds, was just on the basis of that, didn't understand there to be any obligation.
Well, no, you can perfectly well have a contractual obligation to use reasonable endeavours and not best endeavours or commitment. So I'm not sure I follow that point.
My point is this, that if there's no obligation to fulfill any particular order, irrespective of size or timing, then I'd say that doesn't fit with what is now being argued in terms of there being an overarching agreement. I say that because at 3 points, looking at the appliant defence to counterclaim, we've got the admission to act as a wholesaler by purchasing drinks products and reselling them. Admission that that includes promotion by virtue of being a wholesaler, and the admission that the claimant agreed to supply its drinks products to the defendant. But it goes back to my point. I suggest that if you don't have any best and evers isn't there. That's something that's subsequently developed, because the case being put initially, as I pointed out, was you would supply everything to meet demand. Whatever demand we had, you have to satisfy it. That was then watered down, but that wasn't admitted. It was simply conceded at trial that that is something that was likely to have happened by virtue of how commercial manufacturers behave. Because that's why I'm looking at Baird.
Can I just have the reference again? I put it away. Which volume?
To Baird, sorry, it's 117.
Thank you.
If we could look, please, at page 294. It's just one sentence, paragraph 23, just under letter G. So this does apply here, which is, in my view, it would be inappropriate at this stage to take too literal a view of the pleading. 24. The crucial point, in my view, arises from the third issue, namely whether the obligations arising from the alleged implied contract be sufficiently certain to be contractually enforceable. Now, of course, we're not dealing with implied contract, but the same points apply, I would suggest. And then over the page at 295, just by the letter G, the distinction between those cases in which the implication of reasonableness provides for certainty and those in which it does not appears most clearly from the speech of Lord Thankerton. He distinguished between cases where the contract provides for an objective standard which the court applies by ascertaining what is reasonable, and those where there being no such standard, the test of reasonableness is being used to make an agreement with the parties which they have not made for themselves. And then, just a few lines. The lease was silent as to the period for which it was to run, the means of its termination, the quantity of mangasite which might be mined, and whether or not the right was exclusive. The issue was whether it was terminable at will or only on notice. The Privy Council considered it was terminable at will. And then follow that through a bit more. Second paragraph, second part of 29 on 296. Counsel for Baird accepted that this involved an obligation on Baird to supply such garments irrespective of whether they had accepted the order. It is not alleged that there was some objective criteria by which to assess what was a reasonable quantity or price. 30. The alleged obligation on M&S to acquire garments from Baird is insufficiently certain to found any contractual obligation because there are no objective criteria by which the court could assess what would be reasonable either as to quantity or price. This is not a case in which the parties have evidently sought to make a contract. The court seeks to uphold its validity by construing the terms to produce certainty. Rather, it is a case in which the lack of certainty confirms the absence of any clear evidence of an intention to create legal relations. That's my point about the 2 points, two sides of the same coin. It cannot be said, let alone a few sentences later, cannot be said, let alone with confidence, that the conduct of the parties is more consistent with the existence of the contract sought to be implied, and in its absence, the implication of alleged contract is not necessary to give business reality to the commercial relationship. So, perhaps going a bit there into implied agreement. If we then look at what Lord Justice Mance says on the matter, it's paragraph 68 on page 306. When the suggested long-term contract is put in these terms, it becomes clear that it would, in case of any dispute, involve the court writing a
Sorry, which paragraph are you?
68.
Thank you.
Involve the court writing a reasonable contract for the parties after making a complete review of their situations, needs, abilities, and expectations. It could only become relevant to seek to identify the impact of such long-term obligations in a situation where actual cooperation had broken down, or one or other party wanted to reduce its commitment to the minimum. So the court would be expected to undertake the exercise in the very situation where the party's actual behaviour could no longer serve as a guide to the answer. I agree with the Vice-Chancellor that this is not an exercise that the court can or should undertake, or indeed which the parties can objectively be taken to have intended. And then 69, finally, objectively, the only sensible analysis of the present situation is, in my judgment, that the parties had an extremely good long-term commercial relationship, but not one which they ever sought to express, which the court would ever seek to express, in terms of long-term contractual obligations. The upshot is that I agree with the judge's conclusion that there was never any agreement on essentials. So, again, I just repeat that that is a clear example of where we are here, albeit not in the implied contract territory.
But it comes to this, does it? And please correct me if I'm putting this wrongly or too simplistically, that the alleged obligation upon which Hammonds now rely, you say, is insufficiently certain to found any contractual obligation.
Yeah.
Is that it in a nutshell?
So far as I need to say, maybe that I've said this already, so apologies if I have, but because one would simply end up with a number of reasonable this, reasonable that, this has to be done reasonably, that has to be done.
And then in the end it's for the court to try and work out what it is.
Exactly.
That's identified there. Are we finished on Bird, or for the time being?
Yes.
So, if that is your case, is it your understanding that that is what the judge meant when he said there was no content?
Yes.
Yeah.
Just a final point on this, which is that learned friend said, well, this contract has been performed over a number of years, and everybody knew what they were doing. I believe it's a point that my lord and ladies already have, which is that that is equally consistent with the purchase order individual agreements, as it is there being an overarching agreement. One simply can't say, well, this is a clear performance of what was agreed in terms of, apart from it being, of course, acting as wholesaler and selling the products, because I have to accept that they were supplied. But it was the purchase orders that generated each contract. It was quite clearly a separate agreement on each occasion, because it would have been perfectly acceptable for a purchase order to be rejected if it weren't possible to satisfy the order that was being placed. That wouldn't sit with, well, we will supply you with our products, which is said to be the admission at 3.3.
Yes, but there is a difference between a party being entitled to refuse to comply with a purchase order because there's a physical difficulty or impossibility in meeting that particular demand, and someone being entitled to refuse a purchase order just because they've changed their mind. And your case has to be that you were in the latter position. Actually, you were giving no commitment at all to meet purchase orders. it was in your commercial interest to do so, so you would expect to do so, but you weren't actually committing to anything. That's your
Yes.
case.
And likewise, there was no corresponding commitment to take anything. And so I think that deals with ground one. Ground two, as I've said, falls away in the event that ground one is unsuccessful. So ground two is another way of trying to get exclusivity brought into the overarching agreement. And
Sorry, you say it falls away on the if ground one does. That's not the way it's put in the grounds of appeal. I know you've made your point earlier about the way it was put to the judge, but it's not the way it's been put on appeal.
well, in terms of there being an implied contract, it is simply not something that this court can entertain if it's not being pleaded, if it's not formed part of the trial. To then try and come to the Court of Appeal and say, well, actually, having had a finding that there is no express exclusivity, and therefore this is not an exclusive agreement, but actually if we rejig this, we can now argue it in this way. That can't be the right way for matters to proceed.
The judge said something about this alternative way of putting it, didn't he? What did he say? One 153.
My point is that, as I hopefully demonstrated, this was not a point in the pleadings, it was not a point that was advanced in the skeleton argument pre-trial, and then crept in, seemingly for the first time, in the closing submissions. And that may be what the judge is seeking to deal with in paragraph 153. But simply to try, and that's why, again, I open this on the basis of the dress rehearsal, because it does seem to be having another bite at the cherry, trying to now say, well, look at the conduct that the judge has found. What we can now argue is this. And that can't be right. But even if I'm wrong on that, we're in the realms of heist that my friend looked at earlier. And the judge was right in his findings about intention. My own friend backs his whole case on a number of points that the judge made. It may be useful to start with heist. Just keep that in mind. It's volume 3, tab 34. And if we look, please, at page 847, paragraph 43, finds that last sentence, in particular, when there was no evidence that that was the intention of the directors who were responsible for dealing with the secondment of the staff and the payment of their services. And then 46 on page 848, about 5 lines down. Lord Justice Voss said, the parties must have intended there to be a legally binding arrangement. And then the final sentence there, looking at all the circumstances and all the documents, it is right to infer that such reimbursements were made pursuant to the implied contract, which the judge found. The judge dealt with this. If you look at Core Bundle page 143, paragraph 148.
Sorry, what is the principle that you invite us to take from Heiss?
It's not simply, my learned friend has said this, you use the phrase crossing the line, or highlighting the judge said crossing the line, and there was an assumption of a common assumption. Well, that's not enough, I suggest, looking at Heiss, because it's not just there being a common assumption. It goes further, it's an intention for there to be some form of obligation. And that's important because the judge specifically finds that there wasn't that intention. So whether this is the last part of ground 1 or heading into ground 2, it's not enough to simply point to the judge's findings that there was a common assumption. This is paragraph 149. So he says this, for the reasons that I've identified, it seems to me there is clear evidence that the assumption crossing the line is becoming a common assumption of the parties. But at 150, he says, but notwithstanding my conclusion that by the beginning of 2017 at the latest, both parties believed that they had a relationship in which Hock was the exclusive distributor for ZL, that does not resolve the issue of contractual variation. The specific problem for Hock here, on its argument about contractual variation, is showing any intention to vary the relationship in the manner pleaded in paragraphs 19b.1 to 19b.3. It would be one thing if they were to plead and prove some conduct which showed an intention to vary the relationship so that ZL was obliged to market its products exclusively, say for certain defined small parts of the market, through Hock, and associated conduct by which this intention was made known and acceptable. What Hock pleads is evidence that the parties assumed that there was such an obligation in existence already, rather than events from which an intention to vary an existing contract could be inferred so as to achieve the obvious intention of the parties and or to give the agreement business efficacy. And then at 151, second sentence. However, in the absence of events from which an intention to vary could be inferred, I do not accept that this underlying common understanding could give rise to the contractual intention contended for by Hock. So my point is that in Heiss, it was said that there is no evidence as to the intention that in the matter of Heiss, that was the intention of the directors. Looking at all of the circumstances and all of the documents, this is again from Heiss, the conclusion was that one could infer that there was such a contract, such an implied contract, because that was the parties' intentions. But here, the judge has made actual findings based on all of the evidence, based on all of the documents, that was not the intention. And that works for me in 2 ways. Firstly, in relation to there being an implied agreement by conduct. So if there is no express overarching agreement, and then also in relation to the alleged variation of the master wholesale agreement. It's important as well to not conflate how the judge has dealt with the matters, the issues in his judgment. My Lord made the point earlier this morning that when we get to 157.2, that is dealing with specific supply agreements. And And this is a situation where, so it says, in those circumstances, one would expect obligations of exclusivity. Indeed, for reasons that I've identified, I'm satisfied that both parties believe that such obligations existed and intended to be so bound. Well, only firm relies on that as being a basis upon which to found the variation, i.e. there's a finding of intention. That's quite clearly in relation to the SSA's issue. One can't reconcile what is said at 157.2 with the words used that I've read out at 149 to 151, where it's made very clear that it wasn't the necessary intention. Just to finish this off, the difficulty would be if we got to the point of common assumptions in the absence of there being a required intention to vary, or there being some form of intention being found, then that could lead to a difficult state of affairs, I would suggest, because there would just be, if both parties just assumed something to be the case. Let's just take a scenario of, as a matter of fact, Hammonds were the only wholesaler for Zymurgorium, and both parties worked on the basis that that was the position, which is de facto exclusivity. That doesn't mean that there was then a corresponding, well, that's now become an obligation on our parts, just because we both assume that I'm not going to go and talk to anyone else because I'm happy with how this is working. So it must be that there's something more than just an assumption. Because if we don't identify the intention to vary, then I would suggest that it becomes problematic to establish exactly what the obligations are.
What is it? What is the assumption described as being? Because it's not just the fact of exclusivity. That the judge refers at 148 to an assumption that there was a right of exclusivity. And then he goes on, as we know, to find at 149 that crosses the line.
Yes. That is what is stated.
I know, I'm just trying to understand exactly what this concept of assumption is.
Yeah.
What it means and how it differs, as the judge obviously finds it does, from intention to vary.
If I'm right in that it's necessary to have an implied agreement, or for there to be a variation by conduct, then if they need the necessary intention, then these are findings of fact. And I would suggest that this court should be very slow indeed in overturning that and trying to find an intention based on the judgment, because the judge obviously has had the benefit of all of the evidence, and if I bring that back to Heiss, one's got to look at all of the circumstances. So unless my learned friend can, or unless the court is willing to say, well, that was clearly wrong, because looking at these series of facts, as perhaps identified within the judgment, I don't mean the sentence at 148, I mean actual events that are listed, then it would be difficult for this court to come to an inference detention. Otherwise, we're back to oral evidence, cross-examination, and who said what people believed.
So can I be sure I've understood this? Do you accept that in this passage from 148 to 152, the judge has found as a fact that both parties assumed that Hammonds had a right of exclusivity?
One 149 says, I note the claimant's argument that the relationship of exclusivity was simply an assumption on the part of the defendant. I agree that if it were no more than an assumption, it would not cross the line of communication between the parties. That would be sufficient to found an argument that it was or became a term of the contractual relationship of the parties. For the reasons I've identified, it seems to me that there is clear evidence that the assumption is crossing the line and becoming the common assumption of both parties. But so there's you can see there's a conflict, or there appears to be a conflict between what's said at 148 and what's said at 149. Because 149 appears to be dealing with the claimant's argument that the relationship of exclusivity was simply an assumption on the part of the defendant. But I can't get away, of course, from the words used at 148. The corollary of the parties having reached the stage when they assumed that Hock had a right of exclusivity in respect of the distribution of ZL's products. I wonder whether, maybe we don't need to vote this, but I wonder whether we start straying into a stopple by convention here as well. Which is
Well, no one's arguing.
No, but
we're simply trying to understand what the judge found.
You see, if you have to read 148 against, well, the whole of the passage from 144 onwards. Or indeed from 141 onwards. At 144, the judge sets out a series of bits of evidence, and he characterises those as evidence relied on by Hammonds in respect of the argument that the parties came to a position in which they each assumed that the defendant was acting as the claimant's exclusive distributor, and then he buttresses that with 145 and 146, which all point in the same way, and the conclusion is that Mr. Dark, in 145, Mr. Dark, by January 2017, did believe that Hammonds was acting as ZL's exclusive distributor, apart from the legacy arrangements. And when you read that, with 148, where he refers to the parties assuming that Hammonds had a right of exclusivity, is it not fair to say that his finding, his factual finding, is that both parties assumed by January 2017 at the latest that Hammonds wasn't just in fact the only distributor, but was the exclusive distributor in the sense that it had a right to prevent anybody else from distributing? That's what exclusivity means. It's not just I'm the only one, but I'm the only one to the exclusion of anybody else.
simply because there was such an assumption that if the parties simply assume that, then why did the judge then go on to say that that's not enough?
Well, that's the question.
There needs to be intention, because that's the only way one can vary that. So I'd say that's not wrong for the judge to have said, well, this is what the parties assumed the position to be, but neither party intended to vary the overarching agreement.
That would make more sense to me if they were privately held assumptions that weren't communicated. But he specifically finds that, I think this is what the crossing the line means, there was an effective communication in one way or another of that assumption. And I have to say, I'm still struggling a bit about what the difference is between that and intention in the context of contractual variation. Let's look at it in the variation alternative.
But it's possible for parties to assume a position, but not to intend to vary an agreement.
Are you saying they're just mistaken then? I formed this assumption, but I'm mistaken. There isn't any such contract.
Well, isn't the difference? It becomes a difference between. Trying to make sure I get this right, but in terms of one is assuming a factual position. So I assume that there is exclusivity, but I don't intend for there to be contractual obligation, or to put it in the context of this, I don't intend for the overarching agreement to be varied so as to import exclusivity. We're just working on the basis that there is exclusivity. Then they are two, I can see they can mutually coexist. Because otherwise, whenever there's an assumption, or both parties make an assumption, it would lead to an automatic
yes,
variation.
which can't be right if there's no communication. But the judge makes these findings about crossing the line that take this beyond a privately held subjective view. Or appears to.
Well, the judge. I appreciate the judge's finding at 145, but it's actually put in a way of it was because of a communication, and the judge says, "I'm satisfied that AD's failure to query that email is because." So this isn't a scenario where there is a positive statement by Aaron Dart.
Okay, we need to, as Justice Nugee said, that we need to read the earlier passage as well. We've probably taken this about as far as we can, but there's another set of evidence at 144.
Yes.
So what it comes to is this. You're saying, notwithstanding a factual finding, assuming this is what the judge found, that Hammonds thought that ZL had agreed that Hammonds would be the exclusive distributor and told ZL that, and ZL thought that it had agreed that Hammonds would be the exclusive distributor and told Hammonds that. Actually, they hadn't agreed that?
Well, I don't see where the second part in terms of that ZL had agreed that. So I appreciate my lord maybe
Well,
thinking about 148.
but
and the
well,
right of
okay.
exclusivity.
I'm not sure we need to go there because the judges actually made the finding that both parties assumed, and he did that on the basis of the evidence.
See, if we apologise if I'm labouring this point, but if we look at the bottom of 150, page 143, the judge characterises this as what hoc pleads is evidence that the parties assumed that there was such an obligation in existence already, rather than events from which an intention to vary an existing contract could be inferred so as to achieve the obvious intention of the parties and or to give the agreement business efficacy. So, so notwithstanding the points that we've just looked at, the judge is then saying that those points are that an obligation exists already, and presumably that sits with the argument that there was exclusivity from the outset, argued by Hammonds. So it doesn't. So maybe the argument, maybe the point is that it doesn't make the intention point, doesn't crystallise the intention, because there wasn't actually an intention to vary by virtue of it was already thought to be a state of affairs by Hammonds. I'm just trying to understand, or trying to look at what that sentence says, because that doesn't appear to fit with the way in which my ladies and my lord are.
Well, what do you say by the judge's finding of January that there was exclusivity? What, if any, intention can be derived from that? I'm just very mindful of that last sentence in paragraph 151, which I confess I'm grappling with at the moment.
Sorry.
I'm sure it's my fault.
No, it isn't. I'm sorry. I don't think I really understood the question that my lady asked. I'm sorry. I was just trying to work that through, and I lost the thread.
That's fair enough. It is quite simply that the judge, having made the finding that by the beginning of 2017 there was a common understanding of exclusivity, what, if anything, is to be taken from that, certainly insofar as your case is concerned?
It may be that the answer is that it just goes back to the purchase orders argument that was advanced by Zymurgorium. I have to accept that there is a tension, or apparent tension, between what the judge is saying at paragraphs 144 through to 149. But then the following paragraphs, which then say, but actually, and then seems to say that it is actually of a different quality than one might have been reading the earlier paragraphs. all I can really say on that, I would suggest, is that if it's necessary for there to be an element of intention, and or that if assumption and intention are in some way part of the same principle, that the judge comes to the conclusion that there wasn't the requisite intention, and or therefore the assumption is not one of the necessary quality to not of the necessary quality to give rise to the variation, because it's the only way in which one could reconcile paragraphs 144 onwards with then 150 to 152. So whilst we are, the difficulty of then trying to understand someone else was thinking, collated all this evidence, shrinking it down to this judgment. But that must be what the judge had in mind, was either tension was a separate element, or that the assumption was not, as I said, the necessary quality to give rise to the variation. Because it would seem, in what is a generally well-reasoned judgment, for the judge to have said all of these things, and then not sort of 30 pages later said something else, but these two are juxtaposed. The judge must have had that in mind when coming to his conclusion, weighing everything up.
So, can I be sure I've got this right? Your first point on this aspect of the case is, and I think this is the way the judge approached it, what's pleaded is a variation of the original contract. So if there's no original contract, there's nothing to vary, and you don't get it. So this is technically all obiter in the judge's judgment. He says, this is what I would have decided if it had arisen, but it doesn't arise because there's no overarching agreement at all. And then your second point is that if you're wrong about that, and it's open to the appellant to run ground 2 in the way that he wants to run it, which is that these facts, these factual findings, are enough to give rise to an implied contract at the time, or to a variation if there was a contract. What the judge is saying is, well, that may be what the parties assumed, but that's not enough to give rise to a varied obligation. Now, I'm having some difficulty in understanding. One can have contracts which evolve, and a classic type of case of a contract which evolves is one which is never written down. It's all very informal, and parties' relationship develops as time goes on. That's exactly when contracts can evolve. Why is this not a contract which can evolve just because that's how the parties have come to see it?
If it's bear with me one minute. I wonder whether a better way of looking at this is what the consequence of this is said to be. And we did look at the pleaded case on this. The variation of 19b, which is core bundle, page 169, 171 tab 12 is that ZL would not directly supply or attempt to supply directly its products to customers who were the subject of a specific supply agreement, while the master wholesale agreement and or the specific supply agreement remained in force. That each party would provide them with reasonable cooperation as necessary to perform some parties' obligations under or by virtue of the master wholesale agreement or any specific supply agreement. Then 3 is that it wouldn't be terminated without 12 months notice. So I appreciate we've just been discussing about, well, this is a point about exclusivity, but what is it that Hammonds is, that they don't even say here that the consequences of all of these things pleaded equals exclusivity. What they say is because of all the things that have been pleaded at 19A in the reply and defence counter, sorry, in the defence and counterclaim, is that very specifically specific supply agreements. Now, because of the findings the judge made in relation to specific supply agreements, that becomes largely irrelevant because it was effectively said, it was said that there is an element of exclusivity there. So that deals with 19B.1. Then we're in the realms of reasonable cooperation, as was necessary for the performance. I don't believe it to be said that there was, or there's any positive case advanced in relation to that, and there wasn't cooperation given. I mean, the relationship fell apart in around December of 2018. And the issue of whether it was a issue in relation to notice period is something that's live in these proceedings, but in any event is a factual finding that will be dealt with as to whether it's 12 months or not. I don't believe it to be said that this was a termination that was arbitrary, irrational, or capricious, as is pleaded at 19B.3. So it's important to bear in mind what the field upon which we were playing at trial. Because we appear to have got to a position of, well, if there's no express exclusivity which was not found, then it can be implied by virtue of the facts at 19A. But that was never the position that was being adopted. It's never been said that there was implied exclusivity. So, whilst I appreciate there have been many questions about the pleaded case in terms of what was agreed at the meeting in November 2015, but what is source for the goose has got to be source for the gander, in that this is their pleaded case, and it's not said that there was any form of implied exclusivity. This is just another scenario where seemingly the facts, as they've now fallen, give rise to a further argument that, oh, well, actually, we could argue that there is exclusivity in this way. And this is, bearing in mind, exclusivity was a point that was at large and was brought in. This is the Hammonds Part 18 response. And the way this came about was that it was in the witness statement of Jonathan Hammond for the first time, saying there was exclusivity. And so, on the basis of that statement, a question was asked in relation to 3.1.2. This is supplemental one on page 5. It's necessary to go there, but it says, is it the defendant's case that it was agreed between the parties that the defendant would be the exclusive wholesaler of the products? And then the answer is threefold. The phrase exclusive wholesaler is capable of meaning either A, that all products go through that person, including those sold by other wholesalers who have purchased from that exclusive wholesaler, or B, there is no other wholesaler apart from that person. 4, in the present case, the defendant alleges that at the meeting on the 16th of November 2015, it was agreed that with the exception of a few small accounts, all other sales of Zymurgorium products would go through the defendant. And then 5, accordingly, and specifically in response to the request set out above, it was agreed between the claimant and the defendant that the defendant would be the exclusive wholesaler of the claimant's Zymurgorium products in the sense that all Zymurgorium products, with the exception of a few small accounts, would go through the defendant, and the defendant would then sell on those products, including to other wholesalers. So they were asked to clarify their case. That's how it was clarified. And so we're left in a position, I would suggest, where whilst we're trying to unravel what the judge meant about assumptions and intentions, but actually the underlying case, pleaded case, wasn't that there was, well, if I'm wrong about there being an express exclusivity, then, well, we'll just imply it. That would be an easy pleading in the alternative. As I said, this is the Hammonds case evolved over time, hence we got to the re-amended. So I pointed out we had a tripartite agreement in respect of the SSAs at one point. And this is just, I suggest, it's the character of how this case has developed so far as Hammonds is concerned, which is pivoting once we get to a different point. So, well, actually there was exclusivity expressed, despite at 19C.6, the express pleading that there was no express exclusivity. So it's a constantly changing position. And we are just in exactly the same, we're still in, in other words, we are still dealing with Hammonds trying to make a case out as to exclusivity, as to an agreement. Because we're now getting to, well, actually, if we're wrong on this, then it's an implied contract. If we're wrong on this, it's implied exclusivity by variation. That can't be a way of litigating matters and identifying contracts that are agreed order.
So effectively you're saying the judge went in his strictly over section that we've just been looking at, went beyond the ambit of the pleaded case.
Yes. And
because the pleaded case was either express exclusivity or later implied, but only in relation to the SSA arrangements.
And I go back to a point I made earlier, which was when I took my lady through the opening skeleton argument and the closing submissions. That's where this idea comes in for the first time. And so it may be that the judge has picked that up in the closing submissions. But of course it doesn't make it right. I don't recall there being any argument, for example, as to whether there was an implied agreement or whether there was an implied variation in relation to exclusivity. I can check, or I'll be corrected if I'm wrong on that. But it goes to clearly a fairness point of this matter was dealt with over a long period of time, trial, lots of disclosure, witness evidence, and so on. And it may well have been that there would have been further evidence or other disclosure given if it were said that actually this was an implied contract. I don't know the answer, I'm just positing it as a hypothetical. But the fact that it may be that it's simple to just enough to say that this was an overt element. I appreciate that if this court finds that there was an overarching agreement, that it may be necessary then to come on to that. But I'm not sure that that actually gives an answer to second ground of appeal, so that this court could substitute in exclusivity by an implied variation. my ladies and my lord, may be pleased to hear that you don't have too much to say on ground 3.
Well, it's important you say all you feel you need to say.
Yes, no, I will. I make the point that this is, I perhaps can say that relational contracts have become quite fashionable. One can see that from the numerous decisions that are currently making their way through the High Court and the Court of Appeal. It appears that we're in a situation where relational contracts are here to stay, but as far as I'm aware, there is no Court of Appeal authority dealing with the matter, let's say categorically. They appear to have been dealt with in very particular circumstances. But it's important to bear in mind that it's an implied term. And as my learned friend says, Yam saying makes it clear that it's to be analysed in that way. What appears to be happening is the Bates criteria are being used almost as a checklist, but to some extent they are, can I say, they perhaps could be a little tighter. And my learned friend is using Bates in that way, saying, well, look, actually, I can make good on points 1, 3, 7, 5, and therefore I must have a relational contract, and therefore there must be good faith. But English law has always had an aversion to implying good faith into agreements, and there's academic literature on that, and we don't need to go there. I say that from the start because my learned friend says the judge got it wrong because he simply applied Bates. But there's some difficulty in that submission because on the face of it, that's how he asked the judge to deal with it. If we look, please, at Supplemental Bundle, page 198. So issue 3, so page 218, paragraph 218. Relevant legal principles concerning relational contracts are set out in section F8 of Falk's opening submissions. That's at page 107 of that. But then he says this: the non-exclusive list of factors identified by Mr. Justice Fraser in Bates and Post Office that forms a useful framework for an assessment of the present case. And then he goes on to explain why the Bates criteria apply, he says, in this case. So I suggest that having asked the judge to consider Bates and use Bates as a bit of a checklist, to then criticise the judge for saying, well, actually, you got this wrong because you just applied Bates, that can't be a good submission. But ultimately, this is a case that is so far removed from what a relational contract is. Simply because a contract is open-ended, it doesn't mean that there's going to be an implied duty of, or implied obligation of good faith. Otherwise, we're going to get into a position where, if this is necessary to be cooperation between the parties, where it's an open-ended agreement, therefore can be classed as long-term, it's not produced in writing, one can quite easily see how relational contracts are going to become more and more part of contractual disputes and or disputes more generally. As I said, it's become fashionable, one can already see that happening. But applying the facts to this case, the judge was right in how he approached it. Parties didn't intend for that the relationship would be long-term, the length wasn't fixed, there was no mechanism provided for termination, simply because the parties didn't know how long the contract would last. Doesn't mean that that is, if we're doing the checklist thing, that issue is, that element is satisfied. The judge said at paragraph 168.4 of the judgment, page 150. The nature of the promotion of ZL's products meant that a degree of collaboration was necessary in the performance of the parties' duties, but in large part this was simply a question of two commercial parties whose interests were aligned in the direction of one promoting and selling the other's products. So this goes to the point that I try to make in general, which is that there's always going to have to be, there's many contracts where there needs to be collaboration. And that doesn't mean it's collaboration in a relational sense, if I can call it that. It said that this was relational because HOP provided Zymurgorium with information regarding pricing of competitors' products. The consequence of this was to allow Zymurgorium to assess its own pricing. But this was, again, I would suggest, not a sign of it being a relational contract or becoming a relational contract, but it's just practical cooperation. As my other friend accepted this morning, this was Zymurgorium was a new company with a potentially good product. And so asking Hammonds, for example, well, how do I price this? And getting the answer to that doesn't then mean that this is some form of good faith obligation. Sorry, it doesn't mean that there is an obligation of good faith implied into the agreement. The upshot is, of course, that obligations of good faith are onerous, and the court should be very slow to find that there is such a relationship. Otherwise, it's going to increase the burden on the parties wishing to do business and limit their contractual freedom. And without saying very much more on the point, these are just not the facts that give rise to a relational contract. Further point on this is my learned friend seems to suggest that good faith equals exclusivity, and it doesn't follow that simply because the parties have to act in a commercially acceptable way, that that is a de facto exclusivity. And that hasn't been developed, and crucially, the point hasn't been developed as to, well, apart from, it was said to be commercially unacceptable to, as I understand it, commercially unacceptable to supply JDW directly when there was an SSA in place. But then no obvious breach other than, well, where does that lead you? Presumably the answer is, my own friend would say, well, it brings the whole thing tumbling down because you weren't acting in a commercially acceptable manner. But that hasn't been explored, and the judge doesn't deal with it. And so I do query where this leads us if this court were to find this is a relational contract and there is an obligation of good faith to be implied, what the consequence of that actually is. Because it seems there may not be enough in this case to deal with the consequences. That takes us on to ground 4, and the point here is a very short one. If we may look at alpha, which is bond order 2 42, tab 21, page 413 starts. Paragraph 33 at page 424. Worth just noting this about just over halfway down the paragraph. But there will have been a correlative obligation on alpha, the extent of which was not debated before us, but is most likely to have been that alpha were under an implied obligation to use their best reasonable endeavours to promote the sale of Neptune's valves in the United Kingdom. I'll pause there for a moment because we're in similar territory here. The concept of a party to a contract being obliged to use his best endeavours to promote the products of the other party after notice of termination has been given, by whomsoever it may be given in whatever circumstances, is a difficult one and must also militate in favour of a shorter rather than a longer notice period. Longer period of notice. So that's something to bear in mind here, that we're in the realms of a shorter period. And if we look then at paragraph 38, page 45, taking all these considerations into account and accepting Mr. Jones's submission that we should not interfere with the judge's decision that 12 months was the appropriate notice period unless it was outside the range of notice periods reasonably open to him. There isn't any realistic basis for arguing that the judge was outside of the notice periods that he could find. If, I'm not suggesting this is the case, but if the court were to find that it was at the lower end of the scale, then it's at the lower end of the scale, but it doesn't take it outside of what the judge could find. As was canvassed earlier in this hearing, my learned friend was making submissions. This is a highly fact-specific exercise, and the judge, having heard all of the evidence, has come to the conclusion that 3 months is the appropriate period of notice. And he gives detailed reasons. Gives detailed reasons of why he finds that there is a 3-month notice period. That's page 98 of the core bundle. That's the starting point about the law. My learned friend accepts, as the judge subsequently stated at paragraph 36, that the cases that are cited are of limited assistance given the highly fact-sensitive nature of the position of the finding. Sorry, the page I was looking for was 148, paragraph 164. The judge sets out in the subparagraphs there why he says, or the factors that he considers when determining the notice period. I don't understand my friend's position to be that any of those are challenged in terms of the reasoning and the findings. So the primary point is that it's not for this court to disturb the 3-month finding. It's not outside of the realms of what the judge could find. There are reasons given. Those are cogent reasons. But a couple of additional points. The first is that the SSA customers had no notice period. So whichever customer, regardless of when the agreement was made, was able to delist the Zymurgorium products without any notice to Hammonds. So despite all of their efforts that they've said about creating the SSA, actually, they could have just said, that's it, we're done, we don't want any more of this, thank you very much. That doesn't sit with a 12-month notice period. As my lord said earlier, it was possible for an alternative product, Imaginaria, to be identified or to be developed and got to market within the 3 months. That indicates the reasonableness of the period and the notice period. The cyclical nature of the drinks industry, I would suggest, is a bit of a red herring, because it would appear that if my reference position on that is right, that there is some fluctuating notice period. If you give notice in September, that equals a 6-month notice period or a 12-month notice period. But if you give notice in January, then it's acceptable for there to be a 3-month notice period, because you've got through the Christmas period. That can't be right, I suggest, as a matter of principle, because the question's got to be, as between the parties, what is a reasonable notice period, rather than looking at the facts on the ground. And it's not, so far as I'm aware, not suggested that there's some special position in relation to the drinks industry that notice periods fluctuate as a matter of convention or something like that. But importantly on that point, my learned friend didn't ask the judge to take note of the cyclical nature of the drinks industry at trial. It's not in his submissions. And so this is something which is being raised, dare I say, once again in this appeal for the first time, to try and make good. It was also not my learned friend's position before the trial judge that there should be some differing notice period as between different SSAs. It was, and it appears we've got there again today, which is that it's 12 months across the board, and that was it.
Sorry, you'd say the case wasn't put on the basis of different.
It wasn't. No, it was 12 months for everything. But as I say, we appear to have reached the same landing spot today, rather than it being 3 months for this one, 6 months for that one.
There are two limbs to ground 4. The one you've been addressing is whether the notice period of 3 months for the SSAs that the judge found can be challenged. But Mr. Edwards also had a bit saying if he succeeded on grounds 1 and 2, then there would be a reasonable notice period, and that he invited us to fix at 12 months or to remit. What do you want to say about that?
If my lord, the court were minded to fix a notice period for an overarching agreement, then I would say that the same arguments would apply, in that it would be a 3-month notice period. There's no reason to deviate from that. But if the court is not minded to go down that route, then it would have to be remitted for potentially further evidence, or certainly reconsideration of the evidence that's been heard by the trial judge.
Thank you.
May I just say,
Please do.
one, if I may just reverse very slightly, just back to relational. It's simply this, and it was really, I don't want to develop this too much, but it was simply that my lord identified earlier in the hearing that Imaginaria was created, and there was one of the questions at trial was about how Imaginaria came into being, the evidence suggesting that this was happening months before the relationship broke down. That's important for two reasons. Number one, it might suggest that there was no relational contract because the Hammonds were not acting in what might be described as commercially acceptable, in a commercially acceptable way. But of course, any obligation in terms of relational contract would have to be two ways. So it would have to be both sides acting in that way. And it may be that if this is a relational contract, that leads off into further questions in relation to Imaginaria, because the judge effectively said that there's no relational contract and therefore it doesn't really matter because Imaginaria doesn't take me much further. But I just flag that, if I may, because it is something that's in the mix as to whether that was carried out in good faith, given the timings. But I don't criticise the judge for not dealing with it. He didn't need to, having found that it wasn't relational.
We have no questions on that, but I'm now looking at the time. You've got your cross appeal.
Yes.
How long do you think you're going to be on that? I'm not suggesting it's going to be this afternoon because it isn't.
The position, so the position I was proposing to adopt is that ground 2 is largely does away with ground 1 in the sense that if I can persuade my ladies and my lord that there was no reason to end the quotes other SSAs, i.e. anything other than JDW,
Yep.
then it doesn't really matter whether I succeed on ground 1 or not, because the consequence that follows really doesn't matter. It's really if I fail on ground 2, i.e. therefore everything is brought down, that ground 1 becomes a more important ground for me, because I would effectively be saying, well, actually, there was no SSA in which one could find there was a repudiatory breach. So, sorry, I appreciate I haven't answered the lady's question, but I will. But I just wanted to give the court an idea of that's how I propose to deal with it.
Thank you.
Subject to questions being asked. I don't suggest there will be much more than an hour, if that. In relation to ground 1, it may be that we develop it a little bit, but I'm not sure I can go much further than what I've said in my skeleton argument. In our skeleton
No,
argument.
let me make this absolutely clear. I'm not trying to limit what you want to say. I'm just trying to get an understanding of how long it is going to be so that I know we can safely finish it tomorrow morning, and by the sounds of it we can.
Yeah.
And that's allowing, obviously, Mr. Edwards, your reply on the main response we've heard this afternoon, and then on the cross appeal as well.
Yes, tomorrow morning will be ample.
Good. Right, well, thank you both. And indeed, Miss Norris, thank you all very much indeed. And we'll start 10:30 tomorrow. Thank you.
All right.